All right, so welcome to part two of module two. As we continue our conversation about the Administrative Procedures Act, how it relates to NEPA, and some more just about administrative rulemaking and planning. Um, so first, let's talk about the judicial review of agency action. So the Administrative Procedure Act sets a standard of judicial review for all agency action. So cases are brought under the APA for violation of various statutes. So they're using the APA as a reason um, for bringing about the judicial review. So once a decision called a ROD or a record of decision is published by the agency that's doing the analysis, litigation can begin. And I may have mentioned earlier in this course that the very first environmental impact statement that the Forest Service published was faced with litigation. So, when the courts review this for both procedural and substantive violations. And so, review is based on the administrative record that's kept that we talked about in the previous lecture, and is the agency's reasoning for the rule clear and justified. Um, the importance here of forcing the law. So, is their rulemaking forcing the law that was made on the statutory level? So there's something that's called the arbitrary and capricious standard. So Section 706 of the APA, courts shall hold unlawful actions found to be arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with the law. So arbitrary, so without observance of the procedure required by the law, and capricious is unsupported by substantial evidence or not on the record. So not following the the actual not following the actual procedure within the law. Um, so this is coupled with the hard look standard. So the hard look doctrine, the agency must examine the relevant data and articulate a satisfactory explanation for its actions, including a rational connection between the facts found and the choice made. So courts consider whether the decision was based on a consideration of the relevant factors and whether there has been a clear error of judgment in the rulemaking. Rulemaking and administrative records are extensive, and there's incentives to get issues onto the record early. So related to this is the Chevron doctrine, established in a landmark case in 1984. This provides a legal test to determine whether or not deference will be granted to the federal agency with regard to government agencies' interpretation of a law written by Congress. So it's a two-step process. So has Congress directly addressed the issue? Has Congress provided proper guidance on this particular issue? And is that guidance unambiguous? And two, is the agency's interpretation reasonable? Is it a permissible construction of the statute? So has the agency constructed the statute within its rulemaking that's permissible by the courts? So this is a little discussion about judicial deference. The courts are deferential, meaning um, they will defer to the agency. So they're not trying to substitute their judgment for the agency's judgment. They are not the experts, but at the same time, they're not willing to turn a blind eye and just be a rubber stamp to seal of approval on giving the agency just kind of free reign. It's based on the science and administrative record is the important thing for the court system to keep in place with regards to deference, and so that make sure that agencies follow laws and follow their own rules. So courts are particularly differential in light of technical and scientific decisions, which makes sense because they're not experts, and the Administrative Procedures Act is highly differential. So, it requires that conflicts among experts always be resolved in favor of the government. So, if there's an area of disagreement between experts, they will always side with the government if one of the experts supports the government. And so this is kind of an exaggeration, I think, in this quote, but it's still just illuminating that you know the level of deference to the favor of the government, and the victories in court have come against the government are often in cases where they've just acted with arrogance or an outright obvious effort to evade the law. So something that's more obvious. And so, why are the courts engaged in this level of scrutiny? Because there's a vast amount of power that's given to the agencies, and they have a vast amount of power. There's concern about agency capture and kind of public choice theory, so that the agency could have some sort of agenda or some sort of putting forth its own motives into what it's doing. And so the public is needed as a watchdog, and the public in this case is in the form of the judicial review and the courts that provides a check and balance on the agencies. So one of the major cases within the APA was the Northern Spotted Owl versus Hodel in the late 80s. This is a very contentious case, and so with the Fish and Wildlife Services. So there was environmental organizations that brought action against Fish and Wildlife for failure to list the northern spotted owl as an endangered species. So the Forest Service, or the FWS did a status review of the owl and solicits public comment. And so this is leading up to the case. It asks its own expert to conduct the review, do a biological assessment, and he determines that the harvesting of old growth forests will likely lead to the extinction of the species in the near future, and he recommends listing. So this is their own expert. Fish and Wildlife has his work peer-reviewed, and all the experts are in agreement. So then the decision comes out in 1987 with findings and results of the status review, and the listing of the owl was not warranted at that time. And so the court reviews the case under the Administrative Procedures Act, the arbitrary and capricious standard that we talked about earlier. And so the court says that the standard is narrow and presumes the agency's action is valid, but it does not shield the agency from a thorough, probing, in-depth review. This is where the court has said, they're not there to just rubber stamp the agency's decisions. So what are the results? So the court finds that the FWS has provided no analysis to support its conclusions not to list. And so they are entitled to make their own judgment, but provide no explanations for their findings. So there was nothing documented as to why they chose to contradict what their internal expert said. So the court will reject conclusory assertions of agency expertise where the agency spurns unrefuted expert options without itself offering a credible alternative explanation. So why not list? So hence the service disregarded all the expert opinion on population viability, including that of its own expert, and instead merely asserted its expertise. So it's just saying it's kind of being arrogant in this thing and just making a decision without any kind of basis. So the action is found arbitrary and capricious and contrary to the law, and is remanded to the Fish and Wildlife with 90 days to act. So this was the judicial remedy, and so it was remanding for agency action. So the agency needed to go in and review what had led up to their decision. And so another remedy that can be issued by the court is injunctions, whether these are preliminary injunctions or temporary restraining orders. So stoppage of whatever it is that the agency is doing. All right. So our final kind of topic is how does litigation and NEPA how do they intersect? So um, there's generally two reasons why litigation or that a project becomes litigated is you know major questions that often arise, or there's some sort of procedural questions that come up. So should the agency have prepared an EIS? So did they prepare an EA and but not continue on to prepare an EIS? So major impacts will occur, but they left the analysis at the level of an EA. Was the EIS adequate? Did it consider the relevant scientific information? Was the purpose and need stated too narrowly? Did it need to be did it need to include more topics in the purpose and need of the development of the EIS? Were the alternatives adequately varied in their scope? Were there enough alternatives that were chosen for the particular project? And there's procedural topics and issues that can be brought up to force litigation. Was there enough time to comment? Was there enough time for the public to respond to the draft statement that they put out? Were adverse opinions, comments included and discussed, or were they just ignored? Were effects analyzed for all the resources? So were the impacts disclosed for all the resources that were going to be resultant from this action? Was there enough information to allow for a choice amongst the alternatives presented? So, kind of just a general discussion on the courts in NEPA. So, more lawsuits under NEPA than any other environmental statute. Um, we talked about impacts must be given a hard look by the agencies. Courts will review their own hard look at agencies. Agencies have to show their work. They're the clearinghouse argument for NEPA, so it goes through them. But interesting, NEPA litigation can be used also as a stalling technique. If a certain interest group doesn't want a project to take place, they can, provide a ridiculous amount of comments or try and interfere. Some contentious projects that I worked on, you had a lot of environmental groups that would uh, fill out letters, and then they would send they would get thousands and thousands of people to send letters to the Forest Service, and all this stuff has to be reviewed, so it takes time, and so that their the goal of that agency is to waste the time or take up a lot of time of the people who are trying to analyze a project in order to stall the project from actually happening. Um, so courts defer, as we talked about in this deferment, to agencies to determine, how to do an EIS, how to properly analyze cumulative impacts. What's the proper scale of analysis? What science do we rely on? Then the agencies, have to respond to substantive comments and augment their analysis if need be. So if there's something that's substantive that's issued to the Forest Service, they need to respond to that. And that's kind of NEPA at its best, is that the public or an industry group can present a new area of science, and the agency can respond and use that science to put out the best analysis that they know how to do. The last slide here is just to show some of the district courts. Thanks for this lecture, and I will see you next time.